We advise the opinions and views of the hosts and guests do not reflect those of the station.
Everything we listen to, everything we watch, everything we read, everything we wear. Behind all our favorite things, there is an author, an artist, an inventor. Genuine, real, original. Pushing the limits of imagination and innovation for our comfort, our enjoyment. Making life interesting. Enjoy their efforts. Respect them. They help shape our world.
Good evening, ladies and gentlemen. Welcome to Intellectual Property. For our headlines tonight, the Intellectual Property Office of the Philippines opened its 9th satellite office in Tuguegarao City, Cagayan Valley last February 18. IPO-Phil Director General Attorney Ricardo R. Blancaflor graced the launch at the DTI Region 2 headquarters. IPO-Phil is now located in 10 cities nationwide, namely Baguio, Cagayan de Oro, Cebu, Davao, General Santos, Iloilo, Legazpi, Pampanga, Tuguegarao, and Makati. All trademark and patent applicants need only to go to these IPO-Phil offices or log on to www.ipophil.gov.ph. Attorney Ricardo R. Blancaflor, Director General of the Intellectual Property Office of the Philippines, aims to move responsible destruction of pirated goods up the political and judicial agendas. In a paper presented before the 6th Global Congress on Combating Counterfeiting and Piracy held February 3 in Paris, France, Attorney Blancaflor stated, "It is part of our responsibility to dispose of seized goods in a way that does not harm the IPR owner." IPO-Phil broke tradition last year when it destroyed some 1.7 million pesos worth of pirated CDs, bags, books, computer parts, and medicines at the PNP headquarters through military tanks, road rollers, garbage shredders, butchers, and slashers instead of the usual burning. After seizure and destruction, IPO-Phil sent the remains of the infringing goods to power plant operators, crematoriums, and rubber tire factories to use as coal and fuel. IPO-Phil also cooperated with the Battered Women Association to remove tags, metal components, and other materials from the seized goods. In the aftermath of Typhoon Ondoy, retagged and repackaged clothing was distributed to thousands of victims. Junk compact discs were also recycled and converted to everyday items, including household products, building materials, and automotive parts. The advantage of all these methods is that they add no additional expense to the government. These methods comply with the Clean Air Act and the International Agreement on Trade-Related Aspects of Intellectual Property Rights. Under the law, the IPO-Phil may also dispose of seized goods by selling them, donating them to distressed local governments or charities, exporting them, or recycling them. Meanwhile, researchers from the Illegal Institute of Technology in Marawi and Naawan of the Mindanao State University converged on February 21 to 23 in Iligan City, Lanao del Norte, to undergo a patent drafting seminar. According to Mindanao State University Chancellor Marcelo P. Salazar, this will equip our researchers to prepare applications for patent protection over the inventions and innovations. The IPO-Phil delegation consists of Ms. Rosa Fernandez, Engineer Chamlet Garcia, and Engineer Eric C. Padden. Please join us shortly with Attorney Lope Manuel, Head of the Arbitration Office of the Intellectual Property Office of the Philippines, for more on arbitration. Ladies and gentlemen, welcome back to Intellectual Property. I'm your host, Attorney Sara Jane Suguitan. Tonight, we're going to talk about an alternative mode of dispute resolution for all litigants involving their trademarks, copyrights, and even patents. We're talking arbitration. And joining us tonight is the head of the Arbitration Office of IPO-Phil, Attorney Lope R. Manuel Jr. Good evening, Attorney Lope.
Hi, good evening, Sara. Thank you for inviting me here.
Yes, you're welcome back to the show. And
Yes.
Previously, we launched this intellectual property TV show together in Talk to Harry, wherein we talked about piracy and the other efforts.
I think that was last year.
That was last year, yes, around June last year. And now you're head of the Arbitration Office of the Philippines. And so far, you have already trained accredited arbitrators. Yes, in order to set this arbitration, get this office going, definitely. But first of all, Attorney Lope, for our televiewers, what is arbitration?
Well, arbitration is part of the ADR mechanism that we're launching in the Intellectual Property Office of the Philippines. ADR is Alternative Dispute Resolution. It includes mediation and arbitration. If you go bigger like WIPO, they have an expert determination. But here in the Philippines, we're launching the arbitration and the mediation system, primarily because we have an ADR law in the Philippines, that's ADR Act 2004. And we also have an arbitration law which is more than 50 years old. Plus, we are a member of the New York Convention here in the Philippines. So we wanted to push the ADR project more strongly last year. And this year, we're ready to launch the project in a big way.
By alternative dispute resolution, you mean it's an alternative to litigation, an alternative to courts, and also for cases that are filed in the IPO office involving trademark cancellation or patent cancellation. But how is it different from the usual litigation process? I mean, what are its features and what are the advantages of going into arbitration?
Okay. Last year when I was in Singapore, we were discussing what is the arbitration system here in Asia. And of course, we were reminded that, of course, this is always going to be an alternative, always an alternative to the usual system. We also have, we always have the litigation. We always had the quasi-judicial function of the IPO field. And this we're launching, what we're launching right now is the alternative to the regular system. So
it's an option.
It's an option for the parties. Yes, this is different because number one, you can choose the arbitrators, meaning you can choose the judge. In a regular proceedings, you have a judge. In the IPO field, we have a hearing officer. In the arbitration, you are given the option to choose who will rule on your conflict or who will resolve the problem between the conflicting parties. Second, you can design your own hearing. Of course, we have an arbitration rules, but you can tweak it, you can adjust it according to what you want. Like what we have is based in the WIPO. You have a special provision for trade secrets for trademark cases. And there's also a special provision for IP cases wherein you designed specific experiments that will be specific to the arbitral proceedings. Another difference of this with the regular procedure is that the decision will always be final, meaning you cannot go to the Court of Appeals, you cannot go to the Supreme Court to appeal the decision, which is unlike the usual procedure in the IPO field. Once, for example, the BLA issues a ruling in a case, you go to the Office of the Director General, right?
Yes,
and then the Office of the Director General will make a ruling and it will be appealed to the Court of Appeals and go on to the Supreme Court. While we are very confident in the IPO field about what we do in the case, our turnaround time is very impressive as compared to the other forum.
Turnaround time in terms of arbitration?
In terms of the BLA, we're doing really good. We still want to push the envelope a little bit further by offering an ADR mechanism because this is what happens, or this is what is happening to the rest of the world already. Like Singapore is doing it, Hong Kong is doing it. Of course, New York is very established, London is very established, and we don't want to be left behind. We want to provide the stakeholders an option here in the Philippines.
Here in the Philippines, yes, that's right. And usually, you see, the people concerned or who go into court for cases involving intellectual property are businessmen. And in commerce and in trade, time is of the essence. So you want, normally our courts here are clogged, and that's a usual complaint that it takes a substantial amount of time for cases to get decided, whether in IPO or in the usual courts.
In the usual courts, yes.
So arbitration, on the other hand, provides an alternative or an option for the parties to, instead of going by the usual route of the judicial system, you go into arbitration. You can customize your judge, your hearing dates, your venue, more or less. But it's what you call the judge is not really a judge.
We call that person arbitrator. The system is you can have a sole arbitrator in one case, or you could have a panel of 3. depending on what you choose. As I've said, it is very flexible. So if you want to have 12 in the panel, depending on your budget, you can do that.
You can agree.
You can
the parties
agree,
can
yes, the
agree
parties
on
can
having
do
a
that.
panel of 12. You can have a whole jury.
Yes, you can have a
hearing
whole jury.
out your,
Exactly.
your
Yes.
trademark or patent case.
Yes, and then you can design the hearing. Like if you want it to happen in like a week's time, it could be done. Although some of the cases are so complicated, it's not really advisable to do it in 1 week, right?
Yes.
But also you can agree not to have an actual hearing. You could just submit documents, depositions, and all of that, and let the arbitrator decide without, you know, seeing each other.
So arbitration is what you have the option to shorten or lengthen
Yes.
your hearing
Yes.
process and then the decision process. But everything has to be by agreement of the litigants.
By the agreement between the parties, yes.
By the
It's
parties.
always by the agreement. I have to emphasize that under the ADR Act and even the arbitration law, you cannot force the parties to enter into an agreement.
Are you confident that this will, I mean, compared to litigation, is this a faster mode of solving disputes?
I think yes, we're very confident. Number one, because we have big names supporting us. Our partner for this project is the Philippine Dispute Resolution Center, Inc., which is composed of the more established lawyers in the Philippines. And in fact, some of the members of the board would be retired justices of the Supreme Court. And of course, we have the World Intellectual Property Office, who's helping us design the arbitration rules. They were also here last December. They helped us in training the arbitrators for this project. And they have committed in helping us, you know, establish a name for ourselves and, you know, help the community mature when it comes to arbitration.
Arbitration is not, I mean, it has to be built up in terms of capacity. Not all countries offer or are qualified to arbitrate intellectual property cases.
That's true, actually. Here in Asia, Sara, we have Hong Kong. That's very established, the Hong Kong International Arbitration Center. In Southeast Asia, we have the Singapore International Arbitration Center. Unfortunately, we don't have one here in the Philippines that could be compared to that. But of course, we have the Philippine Dispute Resolution Center. It's really growing very fast right now. And if you read arbitration journals, you would see recognitions of the PDRCI.
Of the members.
And of the members of the PDRCI, the names of the arbitrators there. In fact, some of the arbitrators in the PDRCI are also arbitrating in the big arbitration centers like in London and like in Hong Kong or Singapore.
So these arbitrators are not only, well, they're qualified. You qualify them in the IPO Arbitration Center?
Yes, that's true. We had an accreditation system. We designed a curriculum for, number one, for the arbitrators here in the Philippines. We trained them in intellectual property. As you know, intellectual property is very technical, so you have to explain to them the nuances of what is trademark, what is copyright, what is patent, all of those things. And of course, you cannot have a pool of arbitrators that are only knowledgeable on arbitration because, as expected, their exposure in the IP is not as deep as the regular IP lawyers. So the second part of the training, we invited IP lawyers to train in arbitration. So our experts like Atty. Negre, like some of the more famous IP practitioners in the Philippines, they were invited to join the program, and a lot of them participated in the training. And both of these teams, like the one from IP and the one from arbitration, they joined in a big seminar last December with WIPO to have a specific, or to do a specific training on IP specialized arbitration, where the deputy director of the AMC, Arbitration and Mediation Center of the WIPO in Geneva, was here personally to do the training.
WIPO stands for the World Intellectual Property
Organization.
Organization.
Sorry.
And it is behind the arbitration efforts of the IPO.
Philippines, yes. In
Yes,
fact,
of the
I was
Philippines.
told that the Philippines is the first country in the world to request assistance from WIPO.
In order to build our capacity.
Yes,
for
our
arbitration.
capacity here, specifically for both arbitration and mediation. Like the one in London, they only assisted the office in the mediation efforts.
But not in arbitration.
Not in arbitration. The one, for example, in Africa, there's a group of countries there that form an arbitration center. They requested assistance, but not to this extent. What we requested from them are, you know, a huge or a big deal for them, because we're training arbitrators through WIPO. So there is a transfer of technology directly from Geneva to the Philippines. And of course, we also requested them to help us in designing the rules. And these rules were based in the WIPO regular arbitration rules.
Okay, so you have big names behind supporting your office in order to institute this capacity, especially for the Philippines.
Yes.
And pretty soon you envision that this center will become an arbitration center for all, I mean, at least Southeast Asian Well, disputes? Is that a vision for the arbitration office?
Well, that is a possibility. But when we were launching this project, when we were discussing, our primary concern really was the local stakeholders. Of course, as you know, you're with us in IPO, we have like 400 cases or 500 cases right now.
Pending.
Pending, yes. And of course, we have the special commercial courts here in the Philippines, and they have IP cases themselves. And we want to